All right.
I think we're each going to speak for
Pardon?
we're up to you as to whether you want to do that or.
Yeah, okay. I'll do that. That's fine.
Let's wait a couple more minutes.
Yeah, no problem.
I think the mics are live. That's very interesting. That clock is very prominent.
Yes, yes. It's a new edition. It's only been there about 6 months.
Ah.
How's Gordon doing?
He's good. I saw him over the holidays briefly. I told him about your trip.
Mm-hmm.
He was happy to hear that.
Yeah?
He always enjoys thinking about you.
No, I have something to send him, actually. I've written an article on the prosecutor's office in Ukraine. So Gordon will be hearing from me shortly.
I think you were working on that the last time I saw you.
Yes, well, I finished my little missive. And I think we'll release it to the world tomorrow.
Very good.
And I'll be in touch with Gordon in the next few days. But,
I'd like to wait for John Cruden to be here.
yeah. He was just outside, so he should be...
Morning, everyone. We'll get started in just a minute here. Yeah. Let me see if I can.
Let's go grab people and start this.
You're an index card person like
You're even smaller, huh?
It's very impressive.
I need my sunglasses.
I must be older than you. Well,
I was going to say, decreasing size.
exactly. I can't. I couldn't read that. I would immediately be perplexed. Okay.
I think I'll just sit here.
Should we sit down?
How do you want to do it?
We'll sit down. Well, good morning, everyone. Thank you so much for coming on what is our first major cold snap here in Washington. Clearly, some people might be discouraged and some people might have to confront various issues on the Metro, but I'm so pleased that so many of you were able to get here from the very beginning. My name is William Pomeranz. I'm Deputy Director here of the Kennan Institute, the program that deals with the former Soviet Union. But I am also head of the Rule of Law Initiative here at the Wilson Center. The Wilson Center, as many of you know, is the living memorial to our 28th president. It seeks to discuss major global issues in a multidisciplinary manner and across different regions. The Rule of Law Initiative has a similar strategy to focus on legal developments in individual countries, as well as aggregating these discussions into a broader cross-cultural, cross-disciplinary examination of major legal questions. And I think this is the objective of today's conference, and I'm pleased to be joined by several other programs and organizations that help make today possible and helped organize this timely conference on the rule of law and the environment. A few thank yous to begin with. I want to thank the Wilson Center's Environmental Change and Security Program, which for the last 20 years has explored the links connecting peace and conflict to environmental issues, including forests, fisheries, and climate change. The ECSP is one of the largest and most prestigious programs at the Wilson Center, and you can follow the program's online platform, the New Security Beat, for the latest events and articles on environmental security, climate resilience, and natural resource management. I also want to thank the Rule of Law Collaborative at the University of South Carolina, who brought this conference to us, and we've worked with to realize it. The Rule of Law Collaborative is widely recognized as one of the nation's leading centers for the study of rule of law and the training of public and private sector rule of law professionals. And a big thank you to Joel Samuels, the director of the project, who brought this conference to us. And finally, a major thank you to the Bureau of International Narcotics and Law Enforcement Affairs at the U.S. Department of State. INL, along with the Rule of Law Collaborative, has set up JusTRAC, which seeks to improve the skills and knowledge of individuals funding, designing, managing, and implementing justice sector programs. And it provides a multitude of stakeholders the opportunity to share their experiences and lessons regarding justice sector programming. And that is what we intend to do today. So with that, I turn it over to Joel.
Thank you, Will, and thank you to the Wilson Center for your support. We showed up on their doorstep in September through a relationship I had with Will and Matt Rojansky to talk about partnering for this event. And the Rule of Law Collaborative at the University of South Carolina, as you may have seen in the materials, is a relatively new player in the academic world on rule of law issues. And so when we came to when showed up on their doorstep, didn't know what kind of reception we received. And from the moment we walked in, we've been embraced as full partners, and we've enjoyed the interaction and look forward to collaborating more going forward. Will spoke a little bit about the JusTRAC program, and I'll speak about that here in a second. But what I really want to emphasize is the excitement that we have, and I hope you share, about the program that we have in line for today, and the broad group of stakeholders and players who will both be speaking and participating in the audience throughout the course of the day. When we first proposed organizing this event about a year ago, many of our stakeholders in the rule of law world wondered about how to connect these two topics. And when I started speaking to those active in the environmental space, particularly Carl Brook at ELI and Roger Mark, they reminded me that this discussion goes on in the environmental space all the time. And so the question is, how do we bring together the two groups, the rule of law community and the environmental community, into a single room, into a single discussion? And that's one of the missions, not only of the Rule of Law Collaborative, but of the JusTRAC grant cooperative agreement that we have with the State Department's Bureau of International Narcotics and Law Enforcement. Through the JusTRAC program, we host 4 trainings a year, open to the government and to others in the community, rule of law implementers, on rule of law, introductory and advanced training courses. You can learn more about those on our website, and also symposia of this nature. And in fact, in July, just to give you a sense of the breadth of topics we cover, we'll be hosting a symposium here in Washington on creative and innovative programs in rule of law, thinking outside the box, small budget programs that are making a difference, working with less and doing more in a world where rule of law funding is on the decrease. At the University of South Carolina, we really focus on an interdisciplinary approach to rule of law. We don't think of rule of law as being centered in law alone, even though I come from a legal background and I'm on the law faculty at the university. Our 60 faculty associates run the gamut from traditional programs like geography and political science to public health, the School of Medicine, the College of Social Work, and all of those different entities and faculty from them are part of the core of what makes up our collaborative. Today's discussion brings together, I think, a group of policymakers, both from within and outside of government, who think about the intersection of rule of law and the environment from different perspectives. And as you've seen from looking at the program already, I'm sure, the breadth of today's program is quite expansive, and we know that. And we quite intentionally wanted to bring all of these topics into a single umbrella with the hopes that this will lead to further follow-on discussions in a more focused and narrow way on some of the sub-issues that are discussed today. But it was important to us to bring into a single session, into a single day, the full range of issues of environmental governance, scarcity of resources, the role of the U.S. government within that space, the role of non-governmental actors, the pressures that rule of law concerns place on the environment, and in turn that environmental governance and environmental issues place on governments, particularly in the developing world, where perhaps corners are cut or rule of law pressures lead to poor decision making. And so this full range of issues will be explored through various different specific discussions from speakers who come to this from different perspectives and backgrounds. But throughout this, I think, and I hope we'll have a singular thread connecting these two broader topics. I don't want to add on to the long list of thank yous that Will's already shared, but I do want to thank John Cruden of the Department of Justice for being here. We're thrilled to have you as our keynoter, and really excited to hear your remarks as we launch our day together, and excited also for the opening program, which will happen shortly, in which John will be joined by Roger Mark D'Souza after his remarks for a discussion. One of the things that's very important to us is engaging fully. So you'll see from the very beginning of the day, you will be engaged in this discussion. We will have an interactive day from beginning to end. And I would be remiss if I did not make one comment which was made to you as you entered the door, which is that because this program is part of a grant-funded project or a cooperative agreement, we would encourage you to fill out your evaluation forms. You don't often attend symposia and fill out evaluations, but this is part of the monitoring and evaluation of the work we're doing, and you will hear from us in 3 months on follow-ups, and we'd encourage you please to just take a few minutes. This helps us understand whether these programs are really making an impact. Our goal in JusTRAC, and the State Department's goal, as you'll hear shortly from Bob Gifford, with JusTRAC, is to actually build connections within government across the interagency and with government and policy stakeholders across the community in ways that have tangible impact and make a real difference on rule of law programming across the government. So we look forward to your feedback, and I will now turn things over to Bob Gifford.
Thank you, Joel. I'm with the Bureau for International Narcotics and Law Enforcement Affairs at the State Department. Our interest, as Joel and I discussed before we started this morning, this is a bit outside of our traditional lane. What we do in INL is to deliver foreign assistance to other governments and governmental organizations in the area of criminal justice. We provide in my office assistance, technical assistance to inform program design and program development and management of implementation. To do this, we have agreements with U.S. government law enforcement agencies, pretty much all of them, primarily in the Department of Justice and Homeland Security. To implement those programs, we also have started about 5 years ago a program to establish agreements with U.S. state and municipal criminal justice entities. What we do in my office is employ both those federal agencies and the state and local organizations, including police, justice sector, and corrections, to help us provide technical assistance to folks in other countries. We do this through regional bureaus in the State Department that are responsible for U.S. foreign policy in their particular regions, as well as working directly through our embassies overseas. We are, I'd say in the last 5 years, increasingly interested in non-traditional law enforcement support. We don't actually do law enforcement. We provide technical assistance to increase capacities to implement fair and just criminal justice systems in other countries. So I would say 5 years ago, our interest in supporting international efforts in the area of transnational organized crime was very, very much it's still a big topic for us. Kind of moved us into the areas of environmental crime. While we don't do a tremendous amount of this, we're still in the policy development aspect of this with other countries. We also see that there's a tremendous amount of environmental crime that has now spread, and we've been doing this for about the last 3 years, into wildlife trafficking. When you combine both of those and looking at other environmental crime, we realize from where I sit in the State Department that we have a long way to go if we're trying to help other countries get better at dealing with these transnational issues. What we're looking for today out of this seminar, hopefully, is some areas that are new for us, may not be new for some of you in the room here, but definitely new for us, in ways that will inform how we approach the specific problems in our environment overseas, especially. We don't work domestically. We provide support to other countries. And what we'd like to see, of course, is something that we would be able to use to help drive recommendations for policy changes, as well as help us with program design and program implementation overseas. Things that are reasonable, things that actually work. So we're very much interested in the results of the symposium today. We'll look at it very carefully, and you know, since we generally don't deal with many of the agencies that may be represented here today, we'll be especially interested in how it may inform the U.S. government at the federal level. Thank you.
Thank you.
Great.
We'll transition now to our next panel.
Yep. John and Roger Mark.
Are you going to speak from the podium?
Yeah.
Yeah. Good morning. I'm Roger Mark D'Souza, Director of Programs on Global Sustainability and Resilience here at the Wilson Center. And I'm really pleased that we have an opportunity to focus a little bit more specifically on environmental rule of law. He's going to come back there afterwards. Yeah, okay. We're good. Thank you. So I'd like to introduce you to our keynote speaker this morning. John Cruden is the Assistant Attorney General for the Environment and Natural Resources Division. And before becoming AAG, he served as President at the Environmental Law Institute, the Chief at the Environmental Enforcement Section of ENRID, and as Deputy Assistant Attorney General of ENRID. Prior to joining the Department of Justice, he was the Chief Legislative Counsel of the Army and was the first government attorney to be elected and serve as the President of the District of Columbia Bar, the second largest bar in the nation. He was also the first government attorney to be selected as the Chairman of the American Bar Association Section on Environment, Energy, and Natural Resources. So John has told me not to say too much about his background because there's a lot to say, but we're really interested and very much looking forward to your opening comments and engaging a dialogue based on those comments. So John, thank you.
Roger Mark, thank you. Thank you for the introduction. As I look out onto the audience, I see many friends here, and I also see many people who have spent most of their life thinking about, concerned about rule of law issues and how they affect the environment. And so, Joe, as I mentioned to you, I looked and thought about what you're doing at South Carolina. I'm enormously impressed. I'm enormously impressed by that energy, the vigor, the partnership you have here with one of the foremost groups in the world of Woodrow Wilson. And I applaud you for that, and I applaud you for putting this together. The agenda is excellent. You've drawn from a really extraordinary group of speakers. And so this should be something that we all learn from and gain from here today. I've had the opportunity now to talk about other intersections of the law, so I find this fun. About 2 months ago, I was the Leventhal speaker here in the District of Columbia, and I was really talking about the intersection of environmental law and administrative law, speaking primarily about the evolution of the Chevron doctrine. But this today gives me an opportunity to talk about something that I'm actually quite passionate about, and that is another intersection, the intersection of environmental law, which has its own upbringing, its own history, and the rule of law, which everybody in the environmental community really talks about and embraces. And yet what those contours are, what that means, is oftentimes challenging to all of us. So I'm going to speak today from a particular perspective, and so I'll say that at the outset. First of all, I'm an environmentalist. That will shock no one. And then second, I do lead the Environmental and Natural Resources Division of the Department of Justice. And we have a unique role, and I think that might actually help explain some of the things that will occur and we'll talk about over the conference. And I'm going to try to illustrate what we do in the context of some of the rule of law principles that many of you are familiar with. And so I'm going to say just a little bit about rule of law. Then I'm going to talk about what the Environment Division does in that context. And then I want to give you 3, maybe 4 examples of the application of the rule of law in some of the things that have happened literally within the last week or so at the Department of Justice. And then I'll close with just a few challenges that I think exist for all of us who operate in this space. First of all, this is a large topic. It's an exciting topic. I have much that I could say, and I have a number of examples, but I really do want to hear from Roger Mark and the audience. And so what I'm going to attempt to do is, out of the speech that I have prepared, is summarize portions of it so that I can highlight issues that I think are present. But if you want to see longer issues, by the end of the day, we'll post this on the Department of Justice's website so you can get more detail. But I'll try at least to raise those things which I think are important for us to consider. All right, so everybody knows, or at least many of us have debated what the rule of law means in this context. United Nations has spoken, others have spoken. So here are my top 4. What it means that everybody, governments included, are accountable. The laws are to be clear and transparent and applied fairly. That the process by which they are enacted are in fact understood, that it is enforced with due process, and then finally that there exists triers of fact, that there exist judges who are independent, representative, and have adequate resources. The World Justice Project, which has gone out to grade countries as to their application of the rule of law, have come up with a number of factors that they use when they're grading countries, including the United States, to measure application. 3 of them are particularly applicable to things that I'm going to talk about with you today. They look to and measure the extent to which regulations are effectively implemented and enforced, whether citizens can resolve their grievances through the civil justice system, and whether or not an effective criminal system exists. So there's 9, but those are 3. All right, with that in mind, I want to turn to now a very brief statement of the division that I had, largely because of its outsized impact on the rule of law. The Environmental and Natural Resources Division, which is headquartered in Washington, D.C., roughly 650 people, 450 attorneys, is in fact the environmental law firm for the federal government and practices in each one of our 93 federal courts across the United States. Right now, we're responsible for over 6,000 cases or things that will likely be cases. And so we are the nation's environmental litigator, if you will. About half of what we do are things where we are the plaintiff, where we're bringing a case. So recently, I guess the one that would be most understood is the civil lawsuit that we just brought against Volkswagen alleging Clean Air Act violations. So that is an example of us acting as a plaintiff enforcing laws. But we also get sued and are a defendant in that case. And again, the example right now, probably the best example, is we are defending Environmental Protection Agency's Clean Power Plan, which are those historic regulations for greenhouse gases existing in the future. And those have been challenged, those regulations have been challenged, and we're currently defending that in the Court of Appeals for the District of Columbia. So those are examples. And again, about half of what we do, in fact, is bringing cases for environmental violations, and about half is we're defending, but very often we're defending policies like the Clean Power Plan that the administration has come up with. As the Assistant Attorney General, I have been able to set goals for the division, and those are goals that are designed to affect every single part of the 10 sections that represent the division. Here they are. I don't think they'll surprise anyone. And the very first one is relevant to what I'm going to be talking about today, and that is we're going to enforce the nation's bedrock environmental laws, actually the heart of rule of law concerns. We're going to represent the United States for things like the Clean Power Plan. We're going to protect the public fist because there's money involved in much of this. We're going to advance environmental justice, which includes Native American rights, and provide stewardship for the public lands that exist, as well as something that we've already talked a little bit about, and I'll say more about, and that is protecting those endangered species, some of them very iconic species that are suffering historic declines at the moment. Okay, that is in fact my goals, Environment Division. Now let's turn to the application of those goals and the rule of law concerns, and I'm going to try to do 2 or 3 different cases. I would argue to you and present to each of you that at the heart of rule of law concerns has to be enforcement. Remember, I was telling you the world justice, 3 of the 9 all deal with some aspect of enforcement. We can have, as a nation or another nation, the best environmental laws, the most, in fact, transparent, the best that we can come up with, and those laws are meaningless unless there is, in fact, a timely, effective, and fair enforcement. And there cannot be an emergency too big to bring enforcement. There cannot be an entity too big to bring enforcement, or the entire system comes tumbling down. And so here's my example. In 2010, in April, many of us were riveted to the television watching literally millions of gallons of oil gushing out of the oil rig Deepwater Horizon out in the Gulf. And it took 87 days, in fact, to cap that well. But by the time it was capped, it had created 2 things. It created an oil slick the size of the state of Virginia in the Gulf of Mexico. And it soiled and oiled the beaches, killing wildlife as it went. in a distance from New Orleans to New York City. That is the length of it. And along the way, it created victims. It didn't create just the birds and the mammals and others that died. It created economic victims. Entire communities lost their jobs during that time period. The states, the 5 Gulf states, each and every one of them suffered significantly economic decline all during that time period. And so the challenge for us when we were bringing the case against BP and others was how, in fact, doesn't rule of law apply? Well, one thing you want to do, right, is you want to actually restore the environment to where it would have been but for the polluting event. That's a challenge. Second, what about all of these victims? There's individuals, communities. How, in fact, are they compensated for it? And then finally, how do you deter? How, in fact, do you try to make sure that things like this do not happen again? So those are the challenges, and I would argue that's the challenge every single time that we're applying rule of law in enforcement context. Well, fast forward to now, we had 3 trials, we had 500 depositions, we went up to the Supreme Court several times, the Court of Appeals several different times, but last fall we reached a series of consent decrees, and we have just finished a public comment period for those consent decrees. So that's the transparency part of the rule of law. So not only did we have the settlements, but we put those out for public comment. We had 8 public hearings. We've had over thousands now of comments, and we'll look at that. We'll address that. We'll see if we need to change anything that was in those settlements or in the restoration plan that accompanied the settlement. And at some stage, we'll go to court. And in fact, see if the court will agree that what we have done is fair, reasonable, and in public interest. That's a legal standard. Fair, reasonable, and in the public interest. And if it does, then the consent decree that we have in fact negotiated with BP becomes a court order, and therefore it is clearly enforceable. When the Department of Justice announced it, the Attorney General announced the settlement, when we filed it with the court, again late last year, the 3 different settlements together exceed $20 billion, which Loretta Lynch announced as the most, not only the most significant, but the highest consent decree against a single defendant in the history of the Department of Justice. So not just the Environment Division, but the history of Department of Justice. And so it was huge, it was big, but you still had to bring that action and hopefully resolve it in a way that took into account rule of law principles. I told you, I'm transitioning, I told you now that one of my goals is environmental justice. One of the many ways that I think environmental justice is important is clearly a rule of law aspect, and that is to give voice to those that are voiceless. It turns out, of course, that a lot of polluting events occur and disproportionately affect individuals who do not really have a good voice. That could be a minority community in the United States. It could be Native American land, where again we have tribal issues where they in fact by poverty or knowledge really lack the ability that many of you have to stand up and say, I object, this is not fair, or what you're doing does not actually deter individuals in the future. And so we've been trying to incorporate those and listen to the community as we bring enforcement actions when we can. Not every case can we do that, but when we can, and we have examples, and they're in my prepared comments, of where we in fact have done just that, of listening to the community and trying to include their views in what we have done. There's another aspect, though, of rule of law and enforcement that I just want to highlight for a minute. I have dealt with numerous corporations over my life, sometimes enforcement actions and sometimes working with them. And I really do believe that most corporations that I have worked with in fact, are attempting to follow the law. They hire good people. You know, every once in a while there's mistakes, but there's a lot of adrenaline by every vice president of environmental health and safety in the world. But what happens if there's not? What happens when you're in a country or you're in the United States and someone, in fact, violates the law and they're in a competitive environment? I would argue that violator gets then an economic advantage by violating the law, because that company or an individual is getting by and making a profit that is not only illegal, but it also puts their competitors at a disadvantage. The example is the case we just did just a few weeks ago. It's online. It's a New Jersey case. Was basically fraud among biodiesel buyers, and there's a whole system set up in the Clean Air Act that covers how you get credits. And this man was illegally and very consciously working with others and to, in fact, get around the legal system and make a lot of money, thereby disadvantaging all of his competitors. And so the conviction, which he went through, he was convicted criminally of all of that, then turns to, what does that mean now? Well, if you have the conviction, that is actually not enough, because we want to fulfill those goals of rule of law, of deterrence, but also taking the profit out of illegal activity. So no one is attracted. Here was a sentence announced just last week. He was sentenced to 20 years in prison, 3 years supervisor release, but also ordered to pay $56 million in restitution for his role in the scheme to defraud taxpayers and buyers across the United States. And so again, I would argue, and there's more detail in my prepared remarks, that meets those concerns that I just talked about. Let me do some. I want to, not everything we do internationally, but I've only spoken domestically, and I want to turn to our international issues. And I know on the agenda you're going to be addressing this a number of times, and I would only start by saluting and honoring the fact we now had, just end of last year, 193 members, states, United Nations coming together with really breathtaking goals that are called now Transforming Our World, the 2030 Agenda for Sustainable Development. That by itself should challenge each and every one of us. It's a document well beyond environmental concerns, but the environmental concerns that they address are extraordinary. But one of the issues in internationally that I do want to highlight, because we're doing so much more in that time than we have in the past, has already been mentioned by Bob, and that's illegal wildlife trafficking. If you look at in the United States, what's importation and where does that stand, the illegal activity, and you'd all say, well, obviously drugs is first in that regard. Guns is not too far behind. But illegal wildlife trafficking, it's $1 billion industry. And it affects the entire world. When I was speaking to the House Foreign Affairs Committee last year, I testified not only to the connection of organized crime, but said we are on a pathway that it could be true in our lifetime, that rhinoceroses and elephants disappear. We will be showing pictures to our children of what they used to look like, as opposed to walking out into Africa and seeing them. That is the crisis that we are facing. It is, in fact, an economic crisis, but it's also a rule of law challenge. Because of that, President Obama set up an executive order establishing an entire framework for combating wildlife trafficking. As a result of the executive order, there have been reports that have come out. A task force has been established along with the Department of State and the Department of Interior. The Department of Interior has the Fish and Wildlife Service, so they have a significant role in this process, as does the Department of State, but Department of Justice. And so I'm one of the co-chair of the President's task force And there are over a dozen federal agencies actively involved with senior leaders trying to put all of our resources into combating that. Obviously, there are limits to what we can do because in many cases we're talking about activities that might occur solely in a foreign country. But we do have some tools that are available to us, and we've been using those tools, and later I'll give you just one example of all of that. I was honored because last year I led the administration's delegation to the wildlife conference in Kasane, Botswana, where we had now many of the African nations, many of the Asian nations, China, Vietnam, who are in fact demand countries for illegal wildlife items like tusks and like rhinoceros horns. Those are very popular items. And we all got together to talk about it. And it was one of those rare times, I thought, in my international experiences where we all had common goals. Everyone wanted to see this sort of illegal activity go away. How to accomplish that is really not only the desire of nations, but a challenge. An absolute challenge for the application of rule of law, because it does require exactly what those principles we've all talked about. It does require laws, it does require effective enforcement, it does require resources, and it does require independent, thoughtful judges in order to accomplish those goals. We have, in fact, the department set forth something called Operation Crash, which is a multi-agency impact, really looking narrowly at rhinoceros horns. I have in my office a fake rhinoceros horn that I sometimes use when I'm talking to groups or talking to members of the press that weighs about 10 pounds. That by itself, on the market, ground up, that's what you do with a horn, you grind it up into powder, is worth somewhere between $250,000 and $300,000, that 10 pounds. It's more valuable ground up than either gold or, for that matter, cocaine. Here's an announcement we just did in Operation Crash just last week. We had prosecuted one part of this conspiracy, but the other part of it was an Irish national who, at our request, was then arrested by the United Kingdom and then brought to the United States for the trial. He admitted to conspiracy to travel within the United States to purchase rhinoceros horns and then resell them to private individuals or consign them to auction houses. For his illegal activity, he was sentenced to 12 months in jail. We're also doing a lot in illegal logging area. Illegal logging is extraordinarily important because it is logging, it's devastating to the Amazon and to places in Africa where that's a livelihood issue. It also is reducing our ability to suck carbon dioxide out of the atmosphere because that's what forests do. It also breeds illegal activity, the illegal deforestation. The case that we just did that the National Geographic announced as one of the most significant cases of the year dealt with a company called Lumber Liquidator. Lumber Liquidator was bringing in illegal wood from Siberia, pretending it was coming from Germany, because Germany has actually a good history and then bringing it into the United States. And so essentially they were kind of laundering lumber, if you will. But where they were bringing it out of in Siberia, they were taking away habitat for an endangered species. The leopards and tigers that are there in Siberia use that as habitat. So you can see not only is it a violation of law, but you can also see the connection to endangered species. It is not enough, though, for us to enforce the law. That's an important part of what we do. But remember I said at the outset that the need for having judges that were trained and good and independent and the need to have prosecutors who are experienced in that regard are also important. And so with, in fact, funding from Department of State and USAID, just last year we conducted training courses for judges and for prosecutors in Africa. We've done the same thing in places in South America, and we intend to increase that. And with the view in mind, again, that we're training them how to do wildlife trafficking issues or lumber issues, because that is so important, and it's rather unique. It presents in court some unique challenges, and also we're trying to demonstrate how important that is. In that regard, we're working really well with Interpol, both giving them information and receiving information from them. So this conference, which I applaud, is going to address many of the challenges that remain. And I will be pleased to be here for as much as I can to listen and learn from that process. But we all know, those of us who are working on this in our lives, how significant those challenges remain. So what do? Well, the United Nations Sustainability Goals is a good starting point for us to measure our own success as we look toward clean air, drinkable water, and land that's free from harmful pollution. The specter of corruption still exists. When it does, it undermines public confidence in the rule of law. And as we witness, as I've described, the decline of iconic and endangered species, we know that good laws do not take the place of timely and effective enforcement, which we should all advocate and support. And then finally, accountability for everyone must be our goal, as is the fairness of the process and a commitment to human liberties. In all of this, as we ask ourselves, what is our role? We should all be challenged once again by the words we've heard before of Margaret Mead. Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. So, what have I told you? I've talked to you about some of the rule of law principles that we all endorse. I've talked to you about what the Environment Division has been doing in terms of its enforcement activities to, in fact, embrace and advance some of the rule of law concerns. I've talked to you just a bit about some of our international issues as we both try to address illegal activity overseas, but also provide some help in building capacity in that regard, and then some of the challenges that I see in the future. And so with that, I'm going to sit down and turn it over to Roger Mark so we can talk more about some of these issues. Thank you.
Wow. Thank you very much, John. That was wonderful. I think you covered a wide range of issues, and your passion for the issue certainly comes through. I think you make a number of really valid and important points around enforcement, transparency, and accountability, and I think you gave some very compelling examples, very specific examples where you talk about environmental justice. And I wanted to ask you a little bit more about that. When you think of environmental rule of law, and you think of environmental governance, and you think of environmental justice, how are these different components coming together? What's the interplay of them? And what do you think are some of the challenges in addressing these various areas? So rule of law, environmental governance, and environmental justice.
It's a great question, and the interface of some of those actually present issues. So I'll answer with a case. And so we're on Native American land, Navajo land, and in fact there are a power plant that we believe is violating the law. That was not the fault of the Native Americans, but they became victims of that process because they were breathing the air that coming out of that illegal activity. And so when we addressed and looked at that, our first thing, of course, our first goal, rule of law, has to be to stop the polluting activity. That has to be our first goal, because it also protects the Native American. Then the second is, and to in fact not only stop it, but make sure that power plant then comes into compliance with the law and then they're going to pay a penalty because that deters future conduct. But then what about the Native Americans? So what we did, I think unique in that case, to answer more specifically your question, Roger Mark, was we actually surveyed and talked to the Native Americans. What was your needs in that regard? Because then we could negotiate, because this was a settled case. We negotiated 2 extra things. We negotiated a health clinic, so that in fact Native Americans did not have to go somewhere else. They could go right there and talk about those health problems that might have been associated with the clean air. And then, I thought this was a fun part of the settlement. Now, part of it now are air problems over the years. Many of the Native Americans were using wood-burning stoves in their house. Wood-burning stoves also contribute to health issues, particularly with particulate matter. And so we gave them the option, free, of taking out their wood-burning stove and putting in a modern stove that the company then would pay for. And so those were our effort to try to use environmental justice, use transformation, use their voice as a help to, when we resolve it in a way that benefits everyone.
Excellent. I think that's a fascinating example, thinking that you were able to negotiate a health clinic, but also think about how this sort of behavior change component and giving them options beyond the wood-burning stoves. One of the things that I wonder about, and I think you mentioned this in your introductory comments, is looking at questions of corruption. So I think Joel, in his opening comments, mentioned that you can talk an environmental rule of law, but at the same time, we're not centered on just the law, the legal aspect. We need to contextualize some of these issues. And I wonder if you could talk a little bit about how you deal with a environmental rule of law approach in a context perhaps where everything else breaks down. So for example, in a context where there are few legal mechanisms, there's no real governance, a situation of acute conflict, and you're coming in with a rule of law perspective on that. How do you manage that situation? What's the role of environmental rulemaking in that context?
So before I even answer your question, I need to acknowledge your wonderful scholarship in that particular area, the convergence of terrorism, the convergence of nations, of which the drive for natural resources fuels conflict. And I applaud you for your groundbreaking work in that area. Because I do believe, and I think we all know, that issues like climate change not only are a health issue, but they're a national security issue. Climate change can easily and may well have already affected things like drought, and drought can feed conflict. And so there is, I believe, a very clear relationship between things like climate change and national security issues that we should all be concerned about and address. In those nations that in fact have failed government systems, there is a unique responsibility for international institutions, a unique responsibility for all those of us who address the rule of law, because again, there are victims, there are individuals on the ground who are being adversely affected. In some cases, we actually can bring cases, enforcement cases, where there is a violation of the host country law in our courts, and those are wildlife crimes. And so we have done that. We have done and brought cases where in fact the country itself would not have, but it still violated their laws. We have to prove that. And then they're bringing those illegal activity into the United States there. So that is one of the ways that we can affect it. But I don't think it's a substitute for international efforts to build up the Somalias of the world. And I don't think it's it is just more of a challenge for us when we're looking at capacity building in many places that we can actually not only demonstrate but help. And in that area, the judges are critical to that. I've reached a conclusion now, if you give me a choice between a well-written law and a very independent, very thoughtful judge, I'll take the judge, because I'm likely to have better results than that.
Interesting. So I have I have lots of questions, but I'm going to ask you one more question before we take it out to the audience. So as you look at the agenda that we have for today, you know, there are some components and discussions that we would have around land and water. We're looking at questions around resource depletion. We have a session looking particularly at environmental governance. Over lunch, we will be talking a little bit about the role of investigative journalism and access to information. As you look at the agenda, is there anything that's missing that you think is really important that you would encourage us to tease out in the course of our discussions today? Where would you hope we would end up at the end of the day?
So I looked at your agenda, which I think is spectacular. And so I'm not sure there's anything missing, but there's two parts that if I could, I would be here for. I have other responsibilities, and so I will come back, but I'm not sure. But I would urge you all. So out of the UNEP director in here in North America is Patty Beneke. And I'm sure she'll talk about some of the sustainable goals. I'm sure she'll talk about some of the things that UNEP is doing. And UNEP is trying to fund and trying to get judicial training to work. And I just think that's an area that we should all be endorsing and know about. And then finally, the Vice President of Environmental Law Institute, Jay Pendergrass, who is probably one of the most foremost trainers of judges in the world, and has had across the world the impact of going in and doing the very thing that you and I were just talking about was so important. And every single time I listen, I learn from him, and it's again is an area that I told you is extraordinarily important, and then sometimes does not get the attention in the international community that it deserves. In many instances, because I think we assume the judges are knowledgeable and trained, and that's not the case, or assume their independence, which is not always the case. And so those are two that I would single out that I would personally be very interested in, and I'm sure would learn from if could I be here.
Excellent. Well, let's open it up. My colleagues will come to you with a microphone. I'll encourage you to get to your question quickly. I would like you to give your name and your affiliation so that we are able to have a sense of where the question is coming from. So we'll start here, and I will take a few questions at the same time.
Siap Train AU, I'd like to ask the Attorney General, what does the Department of Justice do with the money post-settlement from the oil spill 2010?
Okay, great. Let's take a few questions. Other questions? Folks haven't had their coffee yet. All right, we have a couple here. Yeah.
You spoke a lot about the Sustainable Development Goals and how this can potentially impact rule of law, environmental rule of law. Wondering, because a lot of the discussion has been how do we monitor implementation of those goals, what are some thoughts you have around appropriate metrics for monitoring the implementation of improved rule of law around the world, especially as we talk about enforcement and independence and impartiality of judiciaries?
Thank you. And who are you?
Oh, sorry, Jesse Worker from the World Resource Institute.
WRI. Great. Yes. Yes.
Jay Pendergrass with the Environmental Law Institute. Thank you, John. But I want to ask other ways that you have thought about for attacking the corruption issue, and specifically, you mentioned the Lacey Act, but what other tools does DOJ have? Is the Foreign Corrupt Practices Act a useful tool, or what else do you have?
Thank you. And I think we have one more up here. Yes.
My name is M.D. Karim. Rules of law involves law enforcement and judgment. This is authoritative process, deductive and authoritative process, and enforcement process. While democracy is inductive process, do you think rule of law is democratic or autocratic?
Okay, great. Great set of questions, John. So what is DOG doing with money post-settlement, monitoring of environmental rule of law in the international global structure, additional tools for attacking corruption, and is environmental rule of law democratic or autocratic? Small set of questions.
So since I'm a government agency, and so my funding is tied to how Congress votes every year on our appropriations, I would gladly give that up if I could just take some percentage of the amount of money that we recover each year, because I only talked narrowly about one aspect. But I think your question was largely dealt with where the money goes for Deepwater Horizon, the oil spill case, because I said, this is collectively about $20 billion. And it goes in a number of, there's 3 different settlements there, and so each one of them are different in that regard. First one, the easiest one, in some ways, is the penalty. The penalty was $5.5 billion, so that's the highest penalty ever in the history of environmental law anywhere in the world, $5.5 billion. A special law, ordinarily penalty goes into the U.S. Treasury, not in this case. A special law was passed so that 80% of that money goes to Gulf restoration, and there is a organization set up under the law called the Restore Act, which governs how that money is going to be used, and it consists of a number of federal agencies and the 5 Gulf states. So that money goes to restore the Gulf. The second part, remember I told you that what we're trying to do is to make sure that we could restore the Gulf to where it would have been but for the polluting event. We call that natural resource damages. The natural resource damages in that case, we estimated and recovered very close to $9 billion. That is handled by the trustee council, and the law indicates that for natural resource damages, the money can only be used, and here's a statutory phrase, to restore, require, or gain equivalent resources. So it cannot be used for anything other than that. So there's an automatic check and balance, and there's a further check and balance because the settlement we have shows where the money is going to be used for ocean recovery as well as land recovery, and sets up a mechanism, but the law itself. And then third is there was separate settlements that we did not do that were done by the states that compensate the individual states and compensate every single county for their economic loss. And so every dollar of that gets accounted for either because it's compensating victims or because it's going to restore the environment. WRI, World Resources Institute, one of my favorites because of their international footprint, and to have you ask me about how we measure is challenging, since you're probably one of the best at that. There are, as I mentioned, places like the World Justice Project that, in fact, are measuring right now a rule of law applications, which is directly applicable to what's happening, what should happen in the future for looking at the Sustainable Development Goals that just were passed and measuring that. I am challenged, and I have been sometimes critical of how those are measured. But I want to measure that, I want to moderate that criticism, because I'm afraid that the controversy as to how you measure now deters us from measuring. And so we now sit down in groups and we try to figure out the best way to do that. And it's very subjective, I admit, and it varies country to country. But I do not want that debate, in fact, to deter the measurement. And I think we're all going to have to accept the fact there's no measurement scheme that's going to be perfect. There's no measurement scheme that's going to not have a lot of subjectivity, but having that measurement is critically important. I have learned in my life as a manager, and particularly true now leading the Environment Division, that it's only those things that you measure that are actually accomplished. And therefore, I believe it's important when we're looking at what just happened in Paris and the CO2 goals that countries came up. We have to be able to measure that. We have to hold people accountable. And I think it's true also for the sustainable goals. But I would look to the World Justice Project, who, again, I've said, I don't think is perfect, but I don't think we're going to get a perfect system. Jay asked about corruption, which we either often ignore or we spend a lot of time working on, and it's very difficult. There's no question that some of the wildlife crime that we're seeing in Africa is fueled by corruption. I was told, though, that 10 people coming across the border into Botswana that then kill an elephant and then take its tusk, that tusk will feed the families of those 10 people for a year. So when we're talking about corruption, we're also talking about the economic needs of a particular country, and we cannot divorce that. We cannot divorce the fact that if you're impoverished country, that's going to affect your need, your desire to comply with the law. And so every single time that we have looked at that and enforced and took action, sometimes against government officials there, I think we've also known that there's a bigger picture there that fuels corruption. And so it is not just enough to enforce. We really do have to look at those things that are driving that corruption. Jay mentioned asked me about not only the Lacey Act, but the Foreign Corrupt Practices Act. Certainly, that is an area which looks at bribery overseas by U.S. And even though it remains controversial, I don't think there's any question, no question at all, that it's had an enormous deterrent effect, certainly by U.S. officials overseas. And that I applaud and think that is important because the U.S., when we're walking the streets of Sao Paulo or we're in Kasane, we want to be able to say, not only do we endorse this, not only do we think that's a moral imperative, but we clean up our own house to make sure that we can be the leaders morally as well as legally. And things like the Foreign Corrupt Practices Act, again, allow us to do so. Rule of law, is it democratic or autocratic? Now there is a fun issue of which we could talk about for some time. And it's back to the rule of law principles that we started out with, where we say laws to be effective have to be clear, they have to be transparent, they have to be fair, and they have to be known by the public to come out of a process that in fact is a process that they can endorse. And I think those requirements, which are very important into our debate, means that this is a democratic process. It means that every law that we see by every country might not be perfect. It might not be exactly what we want. But if in fact they have a law, we want their people to understand it and accept it and to have it part of their ethos. And therefore, I do think that is in fact a democratic process. But remember that I said at the very beginning that it isn't enough to have those clear laws. You have to have enforcement mechanism to make sure that those laws are complied with in order to have a successful rule of law scheme.
Thank you. Please join me in thanking John for an excellent kickoff to today's session. Thank you. And I'd like to invite the panelists for the next session to please come up to the front. Thanks.
It's going to be on our website.
Thank you. All right.
You guys can choose your order. I was going to say, do you have a preference? I don't. Oh, thanks. Do you want to take this one? I will, yes. And I have the new one.
Hi, Lisa. Nice to meet you finally.
Nice to meet you too.
How are ya?
Funny that we should be meeting on stage like this.
Right.
Hello. Nice to meet you, Charles.
Hey, Charles, how are you? Good to see you. Nice to see you. Thank you. It's a little chilly up here.
It is a little cold.
I'm sorry.
Thanks. No ice needed.
Ready to begin? Hi, my name is Josh Eagle. I'm a law professor from University of South Carolina School of Law. This session is entitled Rule of Law Challenges in the Context of Land and Water. And of course, rule of law runs through, or should run through, every area of private and public law. And I thought some about what's special about rule of law in the context of land and water resources, and it occurred to me that one of the common themes in success, I will just call it success, environmental success, is a connection between people and place. And obviously, rule of law can be a tool that facilitates that connection. A quick example, or something I've always found fascinating, in the late 1840s, English and Welsh miners migrated to the Sierra Nevada to begin gold mining. And relatively quickly, before actually beginning mining, they determined that what they needed was some set of rules to govern relationships between the miners who were already there, ones who were coming, and other miners in surrounding areas. And if you ever get a chance to look at these, are some of the most fascinating legal documents. These small watershed-based, I guess, stream-based groups developed what are known as mining codes. There was no government in place to regulate resources. Those codes actually are a really interesting form of kind of self-generated or organic rule of law. They help to establish relationships between the miners, both really focusing on equity between them, but almost more importantly, they helped establish a connection between that entire group mining in that stream and others, future miners who would arrive, and eventually the state government. How did they do that? Well, they were very conscious, if you look at these documents, of establishing a system that would be perceived by the outside world as fair, not only to them as the first people on that stream, but to others. And therefore, they were, because the system was fair, the outside world would see that and recognize this special relationship, a protected and stable relationship between those miners and the place. So anyway, I think place might be the key. We'll hear more about it. Our three speakers today all focus or all work in the area, the intersection of environment and rule of law, in particular land. Our first speaker, Elisa Scalise, is a director and co-founder of something called Resource Equity, which focuses on issues of property and gender. Our second speaker, Chris Joshnick, is the CEO of Landesa, an organization with a long history of promoting or helping to promote the development of land rights around the world. And then finally, our wrap-up speaker will be Charles DeLeva, who is the Chief Counsel in the Environmental and International Law Unit at the World Bank. We're going to try to stick to about 15 minutes per speaker, which should leave us with some time afterwards for questions. So we'll hold our questions until the end.
Good morning, everyone. I'm very appreciative of the opportunity to speak about women's land rights and the environment and rule of law. The main point that I'm hoping to make is that addressing rule of law challenges in land and resource rights and governance can result in gains from an environmental perspective, but gender dynamics have to be incorporated as a fundamental part of that, or the environmental gains will be limited. And I'll try to explain why this is the case. To start with, let's take a look at some of the links between women's land rights and the environment. First, women are among the key users of land and resources around the world. So if you just look at agricultural land as an example, agricultural work is, women make up between 30 and 50% of the agricultural workers around the world, depending on the region and the country. And women and men's roles and interests in land and resources are different. So this means that environmental, land and natural resource policies and programs have to consider the different experiences of women and men if they're going to reach all of the users of land and resources. So that's the first link. The second link relates to impact. The impact of environmental changes are felt differently by women and men, and this is also related to gender differentiated roles. So if you look as an example, in many places in the world, women and girls are often responsible for collecting water for the household. And when the water source is depleted, women have to travel further and spend more time on that task, which adds to their daily burden, but it also means they have less time to engage in other kind of community and household activities. Since men don't collect water, they're not impacted in the same way by the depletion of water resources. And another interesting example kind of relates to that first point is that when faced with pressures related to environmental degradation, men often out-migrate for work, leaving women behind and increasing their farming burden, and what some people call the feminisation of agriculture. Another important link between women's land rights and the environment relates to rights and incentives. Women overwhelmingly around the world have weaker rights to land than men, and weaker rights are associated with shorter-term decision-making on how land and resources are used. So a really interesting study from Ghana found that women who have weak land rights and less access to social power were less likely to fallow land than men because they were uncertain of the duration of their right to use the land and wanted to take full advantage of it for the season that they had the right. On the other hand, a study from Rwanda found that female-headed households who had their land rights formalised were more likely to use techniques that took better care of the land, like terracing and soil conservation, than women in female-headed households whose land rights had not been formalised. Another link between women's land rights and the environment is about exclusion, and that is that in many places in the world, women are excluded from decision-making done at the local level, and that's decision-making related to resource use and management. And that's usually because those decisions are thought of as men's business. I'm going to use an example from Kyrgyzstan. In Kyrgyzstan, pastures are managed at the community level. Both women and men use pastures, but they use them differently. So men tend to use them for grazing. Women tend to use them for tending to livestock, so caring for the health and feeding of the animals, making milk products, that type of thing. Pasture management, that term, has always been thought of as a male task, and so it tends to relate to men's role in grazing and focuses on building roads and constructing bridges and that type of thing. Women's interests haven't traditionally been included in pasture management, both because women aren't included in the management bodies, but also because women's tasks are seen as household tasks, even though they are significantly impacted, in fact, by pasture management decisions. Then a final link between women's land rights and the environment relates to outcomes. Outcomes are different when women and men lose access or rights to land or other resources because of changes in the environment or environmental policies. So many studies show that women and men use income and produce and from land and other resources differently, with women tending to make decisions in the interests of the household well-being, and men don't have that same tendency. And this means that not only do environmental changes affect women and men differently, but that the difference can determine the effect of those changes on other things like health, nutrition, and food security. So there are a few of the links between women's land rights and the environment. The thing to keep in mind is that gender plays a part in how land and resources are used, how they're cared for, and how decisions are made about them. And that is not in itself a bad thing, but the challenge is that it's not neutral. And overwhelmingly women are disadvantaged. The role that they play is seen as inferior. The rights that they have are weaker, as is the power that they have to change the circumstances. So the disadvantage that women face with regard to land and resources can be explained in many ways. Could be the gender division of labour, social norms that prescribe behaviour between women and men, land tenure systems that are based on patrilineal inheritance, where they favour the male bloodline, or marriage practices that have women move to their husband's home after marriage and will and always be thought of as an outsider in that household. But women's disadvantage when it comes to land and resources is also a rule of law challenge. And there are some specific rule of law constraints to stronger land rights for women. So I'll go through just a few of them now. The first relates to discriminatory laws. Sad that we still talk about discriminatory laws because I think they're the easiest thing to address, but when it comes to land rights for women, that's still the case in many places. I think the OECD has a really interesting study that looks at, has a global study looking at laws that just have basic differential treatment between women and men on property rights and inheritance. It's very interesting to look at. So laws may be may be discriminatory on their face. For example, some laws that deny women certain rights to transact in land. Or they could be discriminatory when read in context or when read alongside other laws. An interesting example here, there's World Bank every year does a global study on women, business and the law, and part of that they look within legal systems and within formal laws, I should say, and address the question of property rights, and they do a really good job of delving into that. They have found that in a number of jurisdictions around the world where community of property is recognised as the default marital property regime, I think most of you are lawyers so you know what that means. In those same countries, there's another formal law which states that men are the head of the household and have final decisions on all household matters. So you can see how that law of stating that the man is the head of the household undermines the law that also provides equal property rights for spouses to marital property. Another rule of law constraint for women's property rights are when rules and laws are made that don't include women's voice and women's interests. And the exclusion from rulemaking can exist at the national level, but it also can exist at the more local level, especially when authority for governance of land and resources have been devolved to the community and where the community develops its own rules for allocating and managing land and resources. For example, in Peruvian campesina communities, unless they are widowed, women are never considered qualified members of the community, and it's only qualified members of the community who can make rules about how lands and resources are used. A third constraint, rule of law constraint related to women's land rights, are laws relate to implementation, and that are laws that are implemented without considering gender differences. Looking at arable land can help show this point. Arable land reforms often take a similar process. They start with passing laws that recognise certain rights and certain tenure systems, and then they endeavour to formalise those rights through laws and regulations. And the formalisation often takes the form of titling and registration programs. Oftentimes, the titling exercise itself is seen as a technical one, meaning that it's simply a matter of demarcating boundaries and identifying the owners, and that social issues, such as women's rights, are not important. But actually, gender plays a huge part in how successful these programs are. For example, in Laos, women have strong rights to land in both formal law and customary law. In a land titling program that took place there, to gain a title, a landowner had to do two things. First, they had to go to a public office and make a claim. And second, they had to provide tax records at that public office to provide evidence of their claim. In Laos, it's socially unacceptable for women to visit a public office because the men are seen as heads of households socially, and it's the responsibility of men to file taxes. So those two administrative steps necessary to receive a title to land inadvertently excluded women. And the result was that until this was noticed, women were significantly underrepresented on titles that had been issued, even though, as I mentioned, they have equal rights to property within customary and statutory tenure systems. One more rule of constraint with regard to land rights for women are when land and resource law reform programs either don't adequately account for customary tenure systems, or if they treat customary tenure systems as kind of hallowed ground or untouchable without considering gender dynamics within them. This is a really important point for land and resource policies. Customary tenure systems and statutory systems often overlap, especially in countries with a colonial history. And both tenure systems can apply to the same land, but in practice, one will dominate more people's day-to-day behaviour. And in many places in the world, customary tenure is more relevant to people's everyday lives than statutory tenure, and it's more appropriate for the circumstances. Partially for this reason, there's a growing trend now to better protect and recognise customary systems as equally legitimate with statutory systems. But customary tenure systems also have built-in gender dynamics, and any legal or programmatic effort to protect customary rights without recognising the gender dynamics within them can inadvertently disenfranchise women. The example from Peru that I used earlier helps to show this point. In Peru, the state agency charged with titling community lands takes very seriously the constitutional commitment to campesina community autonomy. It took the stance that it can't get involved in questions of women's involvement in campesina decision-making on land because that's an issue that's internal to the community. But by excluding women from its decision-making, the communities aren't just excluding a critical group of users of land, the women, but they're also violating Peruvian constitutional protections for women. So this means that by supporting one constitutional commitment to campesina autonomy, the state land titling agency is undermining another constitutional commitment to protecting women's rights. And there are other rule of law challenges too, of course, many others, related to women and men's different needs for legal information and awareness, or women and men's different access to formal and informal justice mechanisms. But the point I'm trying to make, hopefully you'll get this, is this, that gender dynamics underlie all land and resource tenure systems. And to achieve environmental goals, land rights of women are critical. And stronger land rights for women are key. To achieve stronger land rights for women, rule of law reforms have to be grounded and have a deep and critical appreciation of the different experiences of men and women, their different interests, their different rights, and their different obligations. Thank you.
I'm up. All right. That was perfectly 15 minutes. That's a high bar. I hate to be that guy, but it is freezing up here. Is there any way to bring a little heat to the podium?
Your remarks.
It's a standard problem.
Is it?
I wish there was something I could do about it at the present time, but
Just a thought.
Do you want to borrow my coat?
Almost. Okay.
That helps.
With those warm words, first I just want to say thanks for the invite. This is a great event and wonderful to participate on this panel. I've only recently moved from Oxfam, where I worked for 10 years in the sort of business and human rights sphere, to Landesa, and land rights were always an issue, but they were never squarely in my focus. But I do have a long history with Indigenous communities and the Amazon in particular, and I just want to start with an anecdote that I was reminded of in thinking about this talk today. About, really right out of law school, I got my start trying to bring a lawsuit against Texaco for what it had been doing down in the Ecuadorian Amazon, a case that some of you may still be familiar with because it's still ongoing. But in the course of that work, I got to know a community, the Sequoia, who were trying to negotiate an agreement with Occidental Petroleum. And the negotiations were going nowhere. The community would keep signing agreements, and the that were kind of ridiculous. They'd be on a single page granting 20-year access to the lands for a few outboard motors and a volleyball court. And then the next week, the community would want something more, and they kept going through this. And we went down, myself and a few others, and we did a weekend workshop with this community to talk about some of the issues with negotiations, some of the things they might want to think about, their rights and so forth. And over the course of the workshop, we got into this role play exercise where myself and another guy were representing the oil company, and the community was negotiating, and they were very tough on us, and they demanded all their rights, and it looked very promising. And by sheer coincidence at that moment, a canoe full of these outboard motorized canoes full of Occidental workers showed up, and the negotiators in this role play ran out to the canoe and started talking very eagerly about the kind of jobs and other benefits they could get from the company. And it was very both demoralizing and disheartening, but also I realized it was sort of formative that to overcome these vast, vast disparities between a community that has been only recently contacted by outsiders and the power that these oil companies and others bring to the table is far more than a weekend exercise, and really demands so much more in order to even that imbalance. More recently, I came across an article that took a look at another community very close by that had been negotiating with Arco Petroleum, and it compared that community in the Ecuadorian Amazon and another very similarly situated community up in Alaska. And they went through all the different characteristics, and it looked almost exactly the same, with one big difference. The Alaskan community came out of that relationship with Arco about 10 times richer, and actually many times more rich than the one in Ecuador. And the one in Ecuador was actually a case I was very familiar with, because it was held up as a sort of one of the leading cases of how well a community could be treated by an oil company. And so it was sort of, not ironic, but it was interesting to see even the best case in Ecuador was so far from what this other community in Alaska had managed. And the difference really was the lack of rule of law in Ecuador. That in Ecuador, despite the good faith of the company, and I think the company was pretty good faith, and all the support to the community, at best, they were able to negotiate some monetary compensation for their lands, nothing on the order of the Alaskan communities, who benefited from strong laws, strong institutions to uphold them and enforce them, and strong capacity of the community itself, which had a history of governing itself and working with outside business interests. And so, in my mind, that was a perfect crystallization of the importance of rule of law. Both rule of law and tenure security for these indigenous communities. And what that rule of law really brings to the communities is not only better development outcomes around livelihoods, food security, and health, but also an ability to protect their cultures and their traditions, an ability to participate effectively in a democracy, and environmental protections. And we've seen that recently with some studies. In particular, WRI put out a recent study that showed how much better outcomes would accrue to giving communities rights over forestry lands rather than trying to have them governed by outside governments. And so you have a whole series of positive outcomes that come with rule of law and tenure security that follow from these three elements: the laws, the ability to implement the sort of institutional strength, and a third piece, the ability of communities and others to actually engage effectively with those laws. And I think those three elements are really important. And you really have to have all three. It's not enough just to have the laws and the effective institutions. You also need that third piece of the capacity of the communities or others to engage effectively. And that means, I think John mentioned the importance of voice, the importance of accountability, and that sort of issue. So 20 years ago, working in the Amazon, we didn't, there was no evidence of any of those issues. The law really was not on the side of the communities. There were no effective institutions. It was sort of a Wild West, and the communities were completely outgunned. Today, things look in some ways a little different, but only incrementally. And that's to say, today we're facing even more threats to land. People may be familiar with the term land rush or land grabs. over the last 10 years, owing in part to demand for food, biofuels, and fuel generally, and minerals, there has been increasing pressure on land across the developing world, in particular in countries that lack strong governance and oversight. Climate change has increased a lot of that pressure, and recent studies say that something along the order of 30,000 hectares of land are lost every day, and another 30,000 are degraded. Much of that land is land that is used by communities, and so there's an increasing overlap between the pressure on these lands and running up against communities that depend on them. In one recent study done by the Munden Project that looked at 73,000 investments in the developing world, 93% of them were said to overlap on land that was occupied by communities, many of those occupied by indigenous communities. That has inevitably sparked conflicts. And another study done by the same group, by the Munden Project, has talked about how impossible it is for many of those projects to go forward because of those conflicts and because of the increasing sophistication of civil society groups to create problems for investors. A recent study out of Harvard said that 50% of mining projects that it looked at were protested or blocked in some way, and 30% were abandoned. A recent study in foreign policy that many people have said may have seen talked about how the land grabs and land rush was actually a bit of a myth, because investors are turning around now and realizing that they can't do business in these countries that are not well governed and where land rights are not protected. And in all of that mix, you have increasing conflict and activists being threatened and killed. And so even today, many of the same issues that I witnessed and many others witnessed back in the Amazon 25 years ago are just as bad or perhaps worse. But there have been some positive developments. One very important one is the normative development around indigenous peoples' rights. And we have seen that through ILO 169, through the UN Declaration on Indigenous Peoples, through a whole other network or architecture of global declarations and norms. Some are familiar with the VGGTs around tenure security. RED Plus talks about indigenous peoples and communities. The IFIs, which we'll hear about, the IFC has its performance standards. The courts, the regional courts, the OAS system, the African system are increasingly protecting indigenous peoples' rights. Constitutions are incorporating them across many countries. Out of those rights has come one clear and overriding principle, the principle of free, prior, and informed consent. And that is, in some ways, the gateway to almost all of these other indigenous peoples' rights, because that's where the sort of rubber hits the road. That's the question of whether indigenous peoples or other communities that depend on forests have the ability to exclude outsiders. And do they have the ability to actually say no to development projects? And it has been an emerging norm, but increasingly recognized by international and national law. And so much of the debate today centers on this question of free, prior, informed consent. Alongside the normative development, we've seen many business groups and industries pick up on this concept of free, prior, informed consent. There was a long process at the UN that resulted in the UN Guiding Principles put together by John Ruggie and others, which talks about indigenous peoples' rights. A number of industries have gotten together and with civil society and created their own sets of standards. So you have the mining sector in the ICMM, forestry under the FCC, the soy in these roundtables, or on palm oil, RSPO, for example. Certain chambers of commerce, interestingly, the China Chamber of Commerce on mining and minerals has recognized free, prior, informed consent. Many banks have started and investment groups have started looking at questions of community rights and even started talking about free, prior, informed consent. And corporations themselves, even when they're not bound, have recognized that their projects are threatened unless they can get not just legal license, but social license, and social license is bound up with this idea of free, prior, informed consent. So when I was working at Oxfam, two of the projects that I worked on really reflected this. One was a community consent index where we looked at mining and oil companies to the extent that they've adopted free, prior, informed consent. And just in the last 3 years, there's been a tripling of companies that have explicitly recognized it. And then on the ag and food side, we looked at the top 10 food and beverage companies, none of which had any discussion or mention of free, prior, informed consent 5 years ago or even 3 years ago. And after some campaigning against these top 10 companies, 8 of them subsequently recognized the concept of free, prior, informed consent. And so you have this very quick movement, and I was struck at the time by how at least outside of the mining, I should say mining companies have been pretty good outside of the oil sector. Companies that are consumer facing, in particular banks, food and beverage companies, are particularly susceptible to reputational concerns alongside the sort of concerns that mining companies have at the project site, and how quickly they were willing to recognize the importance of this concept of social license or free, prior, informed consent. So at a normative level and at a business level, you have this emerging appreciation and recognition of the importance of indigenous rights, indigenous people's rights, and particularly the concept of free, prior, informed consent. But that's still not enough. The institutional capacity that's so critical and the ability for governments to implement these norms is still widely lacking. The ability of indigenous communities and others to really negotiate with companies or to voice their concerns or hold people accountable is still widely lacking. And even some of the legal progress that we've seen is now threatened. There are countries, Peru, for example, Bolivia, Brazil, that are looking to roll back some of the protections for indigenous people's rights. And so that we haven't really gotten nearly far enough on rule of law issues despite the normative developments. The upshot of all of this is that you see now increasingly companies trying to bypass traditional mechanisms for investments and negotiate directly with communities, as they were doing 25 years ago. But in a sense, they are not waiting for the rule of law to catch up. And they're doing it under the rubric of these new norms. And there's a lot of guidance documents out there now helping companies negotiate with communities and try to take account of the sort of rights that these communities have. But it is a very tricky and fraught endeavor when the government is not, or when you don't have the institutional umbrella that would allow either companies or communities to go to when there are problems. And so just the communities and companies on their own is still, in most cases, not nearly adequate to get the kind of real security and benefits that indigenous peoples and investors are looking for. All of which is to say that there have been developments in this critical area of indigenous people's rights and rule of law. But what we still need are these institutional capacities and the capacities of the communities. And there are opportunities for governments, businesses, and civil society groups to help with a focus on that. That's to say, when companies go in and they start negotiating with the communities, they should also be thinking about the institutional umbrella and working towards addressing corruption and transparency and so forth. And when governments, donors, for example, and civil society groups are looking at these issues, they should focus not just on corporate behavior, but on empowering those communities and indigenous groups to negotiate and voice their concerns effectively. And I will leave it there. Thank you.
Thanks, Chris. Charles.
Thanks to the Wilson Center and South Carolina Law School for inviting me to be here today. It's sort of an homage to Woodrow Wilson. I think it's worth pointing out that in a discussion about how we can avoid conflict around the world, that the World Bank was in fact born out of the desire to avoid conflict. It was one of the tools that the Allies at the end of World War II designed in order to prevent the kind of economic collapse and economic conflict that led to World War II. And really, since then, we have been operating with our 188 member governments in efforts to avoid both internal conflict, but also in a transboundary sense as well. And I'm going to touch on those. When we operate, we're usually operating through government-approved projects. So Governments borrow money from the bank to implement projects, but those projects should be in accordance with our policies that are based on sustainable development and support the bank's mission of ending extreme poverty and boosting shared prosperity. And if we can end poverty and we can boost prosperity, then we can help avoid some of the conflict that rule of law efforts seek to achieve. So part of that effort at the global level, John Cruden mentioned the SDGs, and the bank has been very involved in following the SDGs. And one of the things that has been interesting from a career perspective and working at the World Bank is the fact that when you look across our programs, we really engage in all 17 of the SDGs. The bank's a very multidisciplinary organization. So we touch on land and water, environment, minerals, economic advice, health, education. I'm the legal advisor on environment. Within my team, we have a land lawyer who works with a global land thematic group that cuts across all regions of the bank. The reorganization of the bank that took place recently is somewhat relevant to, I think, what we're trying to talk about today, which is that there was criticism of the bank that sometimes it operated like 6 regional banks within one. And so when President Kim took over in the bank 3 years ago, the decision was made to make issues like water, like climate, cross-cutting across the bank. So we now have a global water practice group. We have a gender cross-cutting solutions area so that we look at gender issues across all of the countries in which we operate. We have a climate change solutions area that looks at climate impacts across all of the countries. We have an Indigenous advisor that's looking at Indigenous issues in Africa, Latin America, everywhere, to try to have a coherent approach when it makes sense to be coherent, and then when issues are different. And we should maybe touch on cultural issues that sometimes make these issues different. We can also address that in a sensitive way. But one of the things that we pointed out when the SDGs were adopted was that they, unlike the MDGs, actually include specifically the rule of law. So we now have a global platform embarking on the SDGs over the next 15 years to really embed rule of law in the development practice in which we operate. I want to breach protocol a little bit by touching on environment, even though this is land and water, because John Cruden mentioned wildlife crime and environmental crime. All of these issues, land, water, natural resources, wildlife, they're all interconnected, because when there's not rule of law, the poor suffer in all of these circumstances. On the issue of, and one of the reasons why I wanted to touch on wildlife crime, because the economic aspect of the bank indicated that we're losing $200 billion a year that otherwise rural poor would be benefiting from through loss of timber, fisheries, and poaching. So one of the things that we're trying to do is, through rule of law, support the efforts of organizations like the Justice Department by working with governments that have to decide priorities on where they're going to take development aid, to use some of that development aid to deal with rule of law issues, enforcement issues, as opposed to what otherwise might be bricks and mortar type of borrowing. But when we can connect the economic impact of the loss of what Kenya tourism loss means when there is no elephant or is no rhino, then you can get finance ministers in the world to be interested in borrowing funds that relate to rule of law effort. So whether it's dealing with protecting water, land, or wildlife, these are all related to issues that governments, developing country governments, have to understand the relationship between economic harm and the rule of law. When it comes to land and water conflicts, look around the world today. Look at the Middle East. Look at Iraq and Syria. Look at Sudan. Look at the genocide that took place in Guatemala. All regions of the world have faced horrific circumstances dealing with claims of rival groups over land or water or oil or mineral resources. So when we go forward with development projects today that may affect indigenous or local communities, if it's indigenous communities, we require that before a project takes place that there be the free, prior, informed consultation with indigenous communities, and that we analyze the relationship of their land claims, whether documented or customary, with the impact that's going to take place on projects, and that we recognize the stewardship of indigenous communities with natural resources and build that into project development. As well, if projects would displace or resettle affected communities, we require that prior to the project taking place, you have transparent, open consultations about what the project is going to entail, and that resettlement activities should include within it development outcomes for communities that are going to be affected. Very often today, when these issues hit the newspapers, like you have in the case that Chris was talking about in Ecuador, it's often because of disputes between national or local governments and local communities, and a difference of views over what the rights pertaining to land and water are. So in many of the issues today, for example, indigenous community claims for land may be directly contradicted to long-standing constitutional claims, constitutional rights that a sovereign government may say it claims to natural resources. So for example, in Brazil, while Brazil, as Chris has mentioned, ratified ILO Convention 169, which refers to free, prior, informed consent, it also has constitutional provisions that say that the sovereign state has the right to extractive resources. So the subsurface rights in Brazil, Guyana, these are claimed by the sovereign government in a way that may conflict directly with the surface claims of indigenous communities. As well, World Bank policies insist that if people are going to be resettled or displaced, that protection also be afforded to people who do not have any recognizable legal title to the land on which the project is taking place. We have recently issued a proposed draft of new policies that deal with resettlement. And in consultation on these policies, it's been interesting to see some of the world's largest middle-income countries react to these policies as saying, well, when you do this, you're actually rewarding people who are illegal squatters, people who come into areas without any of the legitimate land title that Landesa and World Bank and other groups are trying to provide to people. So why should we provide them with any of the benefits that resettlement policy normally affords to people who have title? And it's this kind of issue that immediately can lead to conflict unless we find a dialogue and acceptable policies to apply in these kind of land settings. And indeed, as Chris was mentioning, we are seeing, with a population target of 9 billion by 2050 and increasing wealth in many parts of the developing world, tremendous pressure on agricultural land to increase crop output, whether it's the sometimes notorious palm oil or other kinds of food crops. There is this pressure to develop more agricultural land, and very often we're seeing violent conflict between local communities and developers. We saw this, unfortunately, in a major land titling project the bank was doing in Cambodia. Just as Elisa was mentioning, in many countries in which we operate, like Laos or Cambodia, there may be no records at all for people who may have had legitimate title to land prior to the genocide in Cambodia with the Pol Pot regime or the Vietnam War in Southeast Asia. Land records may have been destroyed. So in Cambodia, we quite successfully went in and reconstituted land titles for 1 million people living in that previously war-torn country. But when property values were going up dramatically in Phnom Penh, and developers saw this as an opportunity to speculate on valuable land, in the middle of the night, there was violent eviction of hundreds of families that lived in a sought-after area in Phnom Penh, and a World Bank project that we had been quite proud of was suddenly enmeshed in controversy because of the fact that within Cambodia, where we had land titling activities going on, there was this violent eviction of people in a highly valuable urban area. But we're trying to develop mechanisms to deal with this kind of issue. So for example, when we were asked to go forward and work on carbon sequestration finance to support climate change activity, we said that we would do so, but provided that we accompany those activities with grant mechanisms for indigenous communities that may be affected by those same kinds of projects. So I think what we're trying to do is bring in, and I keep mentioning transparency because I think that's a cardinal element of what John was referring to before. I mean, the communities, whether it's in Louisiana or the communities in Guatemala, they have to see the documents, or they have to be informed of the information that's taking place in the projects in which we're operating in order for them to be willing to accept project activities and not go into a state of conflict. And in some cases, that means we have to be willing to go outside the normal UN languages and translate documents into Quechua or other indigenous languages in order for projects to be acceptable. The last thing I want to touch on is transboundary conflict, because I think this is one of the most interesting aspects of the World Bank's history, if I may. It was in the 1950s, when the bank was just first getting started, that the Pakistan and India were still trying to work out ways to coexist. And one of the critical issues that they had then, and they continue to have today in 2016, is shared transboundary waters. And so in the 50s, the bank was asked to be a party to the Indus Water Treaty, so that whenever there was a potential for conflict, potential for dispute between these two countries, a mechanism existed by treaty to address that kind of conflict. And today, whether it's in Central Asia, amongst the Central Asian states that are having water sharing issues, or in the Himalayan region, or between Argentina and Uruguay, when Uruguay builds a pulp mill that leads to Argentina shutting the bridge between Uruguay and Argentina because they don't agree with the way the project is looking at the La Plata Agreement. One of our obligations in going forward with any project that affects international waters is to be sure that riparians are given all information up front and have an opportunity to object to activities and look at all of the data concerning proposed projects. So those are just some of the ways that we try to avoid and address potential for conflict going forward. And I'll close on just one other point, because I think we wanted to give some new ideas about ways we could go forward. One new idea that we had several years ago was to, instead of randomly identifying when World Bank projects would have grievance mechanism addressed at a local level, in our new policies that we're proposing to have adopted hopefully later this year. We're proposing that all project activities have an independent grievance mechanism available to them so that communities, when they have a potential for conflict, if the rule of law has not been adopted at the judicial level, at least at local level, people have an opportunity to address their concerns. So I'll leave it at that, Josh.
Thank you. Originally, we were scheduled to end at 11:25, but we started a little bit late, so I think we'll shoot for maybe 15 minutes of Q&A. Does that sound about right? So I'll open it up to the floor.
All right, my name is Krista Heiner. I work for Eco Agriculture Partners, and I greatly appreciated all your comments. And I guess I have a question about the interlinkages between like the water, agriculture, land, forestry, climate sectors, and the rule of law for each of those different sectors. Now, I know we were talking about the SDGs and the 17 goals, and it's becoming more apparent that achieving those goals is, it's going to require working together between all those sectors. You can't have water in isolation from agriculture and isolation from forestry. And I'm curious, I guess, if you have experiences with how the rule of law can help to enhance synergies between those sectors and mitigate trade-offs. I guess we sometimes run into issues where the water sector, laws in the water sector conflict with forestry and things like that. So I'm wondering if you have any experiences that you could share with us about that. Thanks.
Taking more questions.
Are we going to answer?
Yes, go, sure. I think,
Go ahead. Did you want to go first?
You can go same seat. You want to go? Okay. That's the question I was asking myself that last night. I was preparing the remarks because I think that's a great question. And there's several ways of tackling it. One is the fact that, look, at the country level, one of the problems that the climate movement has had for so long is that ministries are often very fragmented. Their budgets are often fragmented. The reason that we set up this climate change solution area in the bank was to try to bring these different water ministries, land ministries, forest ministries together in the project setting or in the policy setting so that you don't have that kind of conflict. It hasn't always worked. We have a very difficult project right now, the Kenya Natural Resource Management Project, which has gone to the inspection panel, where there were conflicts between land, water, and forest initiatives, including the indigenous communities that were there that had a different ambition than the government ministries. I think what's great about the SDGs is that they've all been brought together. And it's now up to reviewing processes, whether it's at the bank level or USAID, development agencies, when looking at projects to try to do it in a comprehensive way. The IFIs, the World Bank, the Asian Bank, we have obligations to work together, not at cross purposes. And we have the same government shareholders. So, the U.S. Is the largest shareholder at the World Bank. It's a shareholder in all of the other IFIs with the exception of the new Asia Infrastructure Bank, which I think launched yesterday. But there are opportunities to have this oversight. And I think civil society can also hold our feet to the fire by requiring us to live up to our obligations to have documents put out in advance and then see how these issues are indeed addressed in an appropriate cross-cutting factor. And one phrase we haven't mentioned today, but it's still the U.S. that adopted NEPA in 1972, and one of the best tools for addressing what you're talking about is the basic old environmental impact assessment.
did you want to add something?
Yeah, just a quick comment. I think it relates in terms of understanding synergies, or I would say that there's a lot of work that needs to be done on that across different sectors, and that they exist in practice whether we categorise them differently or not. But I think the key to that is actually back to what Josh had said earlier, and that is linking people to the resources. And because I think if you speak with people, you speak with communities, you speak with women, you speak with men, they will have an understanding of how all these things work together outside of whether the ministry is a separate or whether we happen to do a development program that's focusing on one resource or another. So I really see the opportunities are a stronger link to people who are using and affected by changes in resources.
Lalanath De Silva from the World Resources Institute. This is mostly for Charles, but I'd like to hear the responses of the other panelists as well, if they have thoughts on it. How does the bank, and generally speaking, international financial institutions, approach the situation where its own safeguard policies, whether this be social environmental law relating to indigenous people, have benefits that flow to the different groups who might be affected? For example, you spoke about grievance mechanisms being established. So you have a project, you have grievance mechanisms, you have people who are being displaced, who are being offered compensation, which is not part of the law of that country. You really create, don't you see there's a problem of what some people are calling projectized law? In others, you have project level laws or rules which are imposed by international financial institutions, which is not part of the law of the country. Does that not create discrimination, inequality before the law, which is a serious problem for the rule of law? How do you approach these kinds of issues?
Should I answer? Sure. Well, when we are proposing a benefit that goes beyond national law, that benefit is usually a benefit that has been endorsed by the 188 member governments of the World Bank. So we were in Vietnam a couple of years ago, and some of the line ministries were saying that it's a problem for them when our projects wind up paying a higher compensation rate because we use a replacement value and not a market value for people who may be displaced. And so one way of looking at it is, as I said, well, Vietnam is a member, and the member governments have endorsed replacement value. So they've recognized that in development projects, there may be a law of the project. Now, even if one were to say that that may create an uneven playing field, well, maybe then the question is for governments to come up, because no one really made that point in the 1980s when it was agreed that all development projects would use environmental impact assessment, even though at the time many governments had not yet adopted their version of the US NEPA. And I think, as Chris was mentioning before, we are in a state in the world now where there are many principles that are being enunciated that may go beyond national law. I mean, even the Paris Agreement in and of itself sets out many ambitions that are not yet necessarily part of national law, but there is I think at least a political momentum recognizing that we want to have some of these ambitions. So, unless it's something that is deleterious to all affected people, in most cases, I'd say we probably have a pretty good reason to try to set a higher bar in those kind of circumstances.
Just a quick thought about this, because I see this quite a bit happening with these soft law initiatives or multi-stakeholder initiatives, for example, or even corporate commitments where the companies and others are recognizing rights that go beyond national law. And you would think that would be a promising development, but in many cases, rather than bringing the country's laws to another level of maturity or up, they stand in for the governments and they give a government an escape valve. And so my push around these issues is, in all cases, the IFC or a company or civil society groups can be a pressure for improving national laws if they're looking at them or undermining them. And even in good acts can often undermine them. So the critical issue here is to just go in with eyes wide open, and hopefully these kinds of initiatives will legitimize the more progressive standards and bring the governments along with them by including governments in those initiatives or by forcing some accountability on the part of the government, which I will say, just to give you a finer point on this, when we campaigned against the food and beverage companies at Oxfam, just recently I moved over from Oxfam, we would demand three things. We would demand the company make a public commitment, we would demand that it put it in its supplier code, and we would demand that it engage the governments around that commitment. And that third issue was not something that the companies were familiar with, but we wanted to make sure that whatever movement they were going to make on land rights, for example, they would also insist that governments come along with them. And I think there's increasing room for that, of getting the sort of market pressures to move governments in a progressive direction rather than stand in for them and give them a way out.
Hi, Ben Allen from Billingsley Research. My question is mostly for Lisa Scalise. I found your argument about the importance of gender equity and land rights very compelling, but I wonder if you could elaborate a little bit more on the connection between gender equity and land rights and conservation outcomes. Are women more likely to adopt sustainable practices where relevant, or is the question more one of having the land owned and managed as opposed to abandoned by men who outmigrate? Thank you.
That's a really good question. Thanks for bringing it up. I think the link between land rights and conservation relates to the point that I was making, or tried to make, and that is that weaker land rights are a disincentive to certain kinds of behaviour that, for example, that would conserve resources. And when you think about, in general, kind of arguments for stronger land rights, the argument tends to go with stronger land rights, people will behave differently because they have the long-term view in mind. And I think the thing to think about with women is that overwhelmingly women are using land and increasingly using land and resources because of outmigration and other reasons, and yet they're not at the table. They're not at the table. It's their behaviour that will at least as much impact conservation outcomes as the behaviour of men, but women aren't at the table. And so that's where I see the link is. It has a lot to do with both stronger rights and women's access to the kind of decision-making that's happening at the global level, at the national level, at the regional level, and within communities, so that it's their behaviour and that's changed if needed, but also their interests that are respected alongside those of men who are also using the resources. Thanks.
Okay, I think we have time for one more. Very back there.
Thank you very much for accepting my question. Yes, my question relates to the Philippines and some external factor like the illegality of logging. Illegal logging has been an external factor, but which has been very critical in causing a lot of damage. Now, Mr. De Liva of the World Bank, to the extent that you're familiar with the situation in the Philippines and how international assisting organizations are relating or are partnering with the Philippine government in terms of rule of law and all that, I assume that there is a law that prevents illegal logging in the Philippines. But the problem which leads to my question is that in facilitating international assistance, be it from the World Bank or the Asian Development Bank or from whatever other external international lending or grant resources relating to climate change, would it be possible that perhaps in making a country like the Philippines, which has an uncontrolled illegality of logging practices, would be reviewed and analyzed for eligibility for international assistance that would be given through the government, as you had stated, but in consonance with the law enforcement agencies, and not only the forestry or whatever is the cabinet that program that relates to forestry. But the law enforcing agency that would make it to a country like the Philippines with its problem of illegal logging be eligible precisely for international aid. Is that being considered?
It's a great question, because for many years, international financial institutions stayed out of the criminal justice area and did not work directly with enforcement agencies. One of the things that I think drove a change in that behavior so that there can be engagement with the law enforcement community is the statistic that I gave you earlier on the impacts of illegal natural resource crime. When the economists in the World Bank and other institutions recognized that unless we dealt with the rule of law, unless we dealt with enforcement, we could not stop the damage to natural resources and to the economy, the World Bank issued a criminal justice sector paper saying that it would engage in that sector. For many reasons, that institutions stayed out of it because they have a non-political mandate, a mandate that says focus on economics, don't interfere in political affairs. And there was concern that if you engaged in the justice sector, you might get engaged in what may be political battles. But the world has changed and we've moved on. And so, I mean, we have partnered with Justice Department entities around the world now. In the Mediterranean, we worked with prosecutors that were looking on illegal fishing that was taking place in the Mediterranean and affecting the tuna. And in South Asia, for tigers, we financed equipment that enables tracking of poachers and tigers, and in the Philippines as well. We've been looking at deforestation, and there's no reason why we can't also work with the enforcement community there as well.
I think we're going to have to wrap it up, but let's have a hand for our speakers. And I believe we have a short break now, about 10 minutes.
Yeah, I did. I have some other things I need to do while I'm here. So.
Well, hopefully we can sit down in Seattle sometime.
Yeah, do you get out there very much?
Yeah, I'm out there almost every month.